Hi everyone, welcome back to our channel. Today we are taking a look at part 3 of our top 5 estate planning misconceptions. Misconception number 3. Words in law mean the same thing as they do in your head. There are a few key words used in estate planning that are also used in everyday language. However, the definition in law is very different from the words when we use them every day. Let's take a closer look. So why is this a problem? You may understand the word children to mean the kids that you're raising with your spouse, but the law may say otherwise. When we hear the word children, we assume we know who we're talking about because we know who our kids are. The people we have birthday parties for, take to soccer practice, take to school events. However, in law, the definition of children is drastically different. So let's take a closer look. Why is this a problem? All biological children are included, even if they aren't in your life. Stepchildren are not included. Let's look at an example. Let's say that you had a child in high school and you haven't seen that child since. Now you are married to a spouse who has a child of her own from a previous relationship that you've been raising since it was an infant. Also, you have a child together who is your biological offspring. Let's say that you pass away without a will. The people who would be entitled to a share of your estate are your spouse, the child you had in high school, and the biological child that you have with your spouse. Your stepchild that you've been raising from a baby would not be included. You can guarantee that someone is going to be very upset with you in this situation. What you can do instead. Don't rely on the laws of intestacy to tell you who is in your family. Make a will. You can specifically name your stepchildren if you want them to be included, and you can confirm if you want them to be excluded. If you have an illegitimate child who is no longer a minor, specify whether he or she is to be included. The next term we're going to look at is spouse. In Newfoundland and Labrador, common law spouses have no inheritance rights or dependent relief rights. The bottom line is, if you don't make a will, you don't get to choose who's included. Since common law spouses don't have inheritance rights in Newfoundland and Labrador, if you haven't made a will or owned your assets jointly, your common law spouse could be left with nothing. To leave something to a common law spouse, you must have a will. Whether or not a common law spouse has inheritance rights varies from one province to another. This means that this situation is not necessarily true across the country. But in Newfoundland and Labrador, if you want your common law spouse to inherit anything from your estate, own the assets jointly, or even better, make a will. The matrimonial home. If you are the only owner of the home and you pass away, your married spouse will automatically have the right to own the home. Because you're legally married, your spouse has the right to inherit the property under the Family Law Act. This act does not apply to common law spouses. What you can do. Consider how joint property can be used, and consider how beneficiary designations on items like RRSPs, RIFs, or life insurance policies can be used. Your banker or financial advisor can help with this. By putting your home in both your names, you're ensuring that your common law spouse will be able to stay in the property. If you pass away without a will, your common law spouse doesn't get to inherit the property and may have to move out, regardless of how long the two of you have lived there. So, make a will and make an enduring power of attorney. Once you've passed away, your will comes into effect. By leaving the property in your will, you can make sure that your partner gets your assets while leaving things the way they are for now. Creating an enduring power of attorney also means that whoever's in charge of your finances if you lose your capacity knows what to do in order to make sure that they keep things in line with what's in your will. You can put specific restrictions in there so that the person does not sell your property when it's meant to go to someone else. Today, we talked about how words in law don't necessarily mean what we think they do. Stay tuned for next week's episode when we take a look at the 4th misconception on our list of the top 5 estate planning misconceptions. Where to find us? Visit us on our website at butlerwillsandestates.com Or check out our blog, estatelawcanada.blogspot.ca, or to get in touch with our office directly, give us a call at 709-221-5511. You can also send me an email at chelsea@butlerwillsandestates.com.